आमचा खरंच वकिलीचा पाया आम्ही बळकट करू. इकडे ऑल इंडिया रिपोर्टर नागपूर प्रकाशित ॲडव्होकेट श्रीकांत कानेटकर सर लिखित टायटल सर्टिफिकेट हे जे पुस्तक आहे आपण हे आपल्या सर्व विद्यार्थ्यांना किटमध्ये देत आहोत. आता सहज ते मी चालत असताना त्यात व्हॉट इज टायटल आणि टाइप्स ऑफ टायटल इथपासून ते अगदी ई सर्च असं इथपर्यंत ते अनुक्रमणिका सहज बघत होतो इथपर्यंत दिलेलं आहे. विशेष म्हणजे त्यात मेसेज ह्या भागामध्ये जयंत सरांनी एक असा उल्लेख केलेला आहे कानेटकर सरांचा, त्यांचा भीष्माचार्य असं म्हटलेलं आहे त्यांना. हे महाभारतातलं उदाहरण होतं सर, पण मगाशी आपल्या बोलण्यामधून सेन्सेस आणि एव्हिडन्स असा जो आपण सुंदर समन्वय साधून दिलाय, मला कुठल्याही बेरेक्टमध्ये किंवा कुठल्याही पुस्तकामध्ये हे ऐकायला मिळालं नाही. अशी नवीन दृष्टी दिल्याबद्दल सुद्धा मी आपले सुद्धा आभार मानतो. आता कार्यक्रमाच्या उत्तरार्धाकडे वळताना मी ॲडव्होकेट चौरे सर यांना विनंती करतो की त्यांनी आभार प्रदर्शन करावं.
जे आहे म्हणजे पहिलं पुष्प फुटण्याच्या कालावधीत मी जास्त माझा जो मी जायवर सरांशी बोललो त्याचं एक पहिल्यांदा स्पष्ट करतो. कारण काय होतं की आपण लॉ कॉलेजमधून डिग्री घेतो, सनद घेतो, वकिली व्यवसायात येतो. कोणीही पक्षकार पहिल्यांदा तुम्हाला जामिनाची केस देणार नाही किंवा क्रिमिनल केस देणार नाही. कोणीही पक्षकार तुम्हाला दावा देणार नाही किंवा असं लिटिगेशनचं लगेच सुरू होतं. परंतु तुम्ही ज्या परिसरात राहता, तुमचे नातेवाईक, तुमचे मित्र, तुमचे ओळखीचे सगळं यांना हे माहिती आहे की तुम्ही वकील झाला आणि वकील झालाय तर तो सहज म्हणतो की अरे मला भाडे करार करायचं आहे, मला साठेगत करायचं, मला हिसाब पावती करायची, मला नोटीस द्यायची, हे सहज सहज शक्य आहे. आणि मग आपल्याला लगेच सुरुवातीला काम नाही मिळालं कोर्टामध्ये, मग जायवर सरांनी सांगितलं तसं लगेच नाही मिळालं तर तो आत्मविश्वास नवीन वकिलांचा कमी होऊ नये, तो म्हणजे वकिलांमध्ये आत्मविश्वास टिकून राहावा किंवा तो अधिक वाढावा, तर त्याची सुरुवात जी आहे ती सहजरित्या मिळणाऱ्या कामातून सुरू होईल. म्हणजे डॉक्युमेंटेशन, रजिस्ट्रेशन, कन्व्हेन्स, टायटल हे अगदी सहज शक्य आहे. म्हणजे नवीन वकील घालून कोर्टासमोर काम करायला संधी मिळायला थोडा वेळ लागतो, अवधी लागतो. ज्यांच्या पाठीशी मागे बॅकग्राऊंड असेल त्यांना शक्य आहे. पण ग्रामीण भागातून जी मुलं आलेली की ज्यांचं कोणी ओळखीचं वकीलही नाही, कोणी मार्गदर्शन करायलाही नाही, पण पदवी आहे, सनद आहे, काम नाहीये, तर त्याचा आत्मविश्वास कमी होऊ नये, तो आत्मविश्वासाने उभा राहतो. तर त्याला सुरुवातीलाच काय करता येईल म्हणून हा जो विषय आम्ही जो निवडला आहे. तर मी जे जायवर सरांशी कॉन्टॅक्ट करताना म्हटलं सर असं असं आहे, माझ्या ग्रामीण भागातले खूप विद्यार्थी या कॉलेजमध्ये की ज्यांचे कोणी घरातले कोणी वकील नाही किंवा मार्गदर्शन करायला कोणी नाही, तर याचा आत्मविश्वास आपल्याला कमी नाही झाला पाहिजे आणि त्याच्याकरता लेक्चर सिरीज अरेंज करायचे. तर आपण काय करता येईल याचं. आणि मग जायवर सरांनी सांगितलं आपण एक काम करूया, आपण पहिल्यांदा ड्राफ्टिंग, कन्व्हेन्सिंग आणि टायटल हा विषय ठेवूया की जेणेकरून सुरुवात त्यांची चांगली आत्मविश्वासाने होईल. हे त्याच्या मागचं कारण होतं. आणि ती लेक्चर सिरीज सुरू करायला जायवर सरांनी खूप मला मदत केली आणि मार्गदर्शन केलं. त्याचबरोबर मग म्हटलं आपण एक काम करूया, आज समाज दिन आहे, कर्मवीर दिन म्हणतो आम्ही त्याला संस्थेच्या दृष्टीने. आणि मग कर्मवीर बाबुराव ठाकरे, स्वर्गीय बाबुराव ठाकरे यांच्या नावाने ही लेक्चर सिरीज सुरू करायचं आणि त्याला संस्थेचे सरचिटणीस नितीन ठाकरे यांनी संमत केले. असं हे सर्व कारणामुळे आयोजित झालेला आहे, केलेला आहे. आणि त्याच्या उद्घाटन करायचं तर काय करायचं. आणि म्हणून मग मी जायवर सरांना बोललो, पण सर आपल्याला आम्ही ज्या वेळेला कंटिन्युअस लिगल एज्युकेशन प्रोग्राम राबवत असताना, आजही राबवतो, त्यावेळेस जायवर सरांना वाटतं सर आपण एक काम करू. कारण मी कानेटकर सरांनी इथं सांगितलं आणि मग मी त्यांना वाटतं कानेटकर सरांना बोलवते. त्यांना मग त्यांनी ती पुढची व्यवस्था तर माझ्या उद्घाटनासाठी आपल्याला जे प्रमुख पाहुणे लाभले कानेटकर सर यांचं मी आणि धन्यवाद देतो. त्याचप्रमाणे ही लेक्चर सिरीज दिली आहे या कार्यक्रमासाठी पुढे 7 दिवस ते आपल्याला मदत करणार आहे. बार काउन्सिल ऑफ महाराष्ट्र गोवाचे सदस्य आणि सगळ्यात महत्वाचं जायवर सर हे या कार्यक्रमाचे अध्यक्ष म्हणून उपस्थित राहिले, आमच्या निमंत्रणाला मान देऊन उपस्थित राहिले. त्यांचेही मी मनपूर्वक आभार मानतो. त्याचप्रमाणे संस्थेकडून लॉ कॉलेजसाठी ही व्याख्यानमाला सुरू करावी मी आभार मानतो. त्याचप्रमाणे व्यासपीठावरील सर्व उपस्थित मान्यवर, माझ्या समोरील सर्व सिनियर ज्येष्ठ वकील, विद्यार्थी मित्रांनो, आपण सर्व हा व्याख्यानमाला सुरू झालेली आहे असं जाहीर करू. आपण आता पुढच्या आणि महत्त्वाचं आणि लँड रेकॉर्डचं जे व्याख्यान आहे ते शुक्रवारी होईल. आणि आजचा पहिला भाग जो आहे आजच्या या कार्यक्रमाचा
and therefore the today's subject and effect of non-registration of it. Now therefore I will directly jump, my friends, section 17 of the Indian Registration Act. Section 17 talks about documents which are compulsory required to be registered and certain documents registration of which is optional. Why I am starting this case? The very subject, the registration of a document and registration optional, registration of certain documents. Now my friends, if you see, I know that if you have got this particular, I used to say always my particular students in that case, you must always have, even in the every nominal particular lectures also, at least bear. If you are attending the lecture of particular CPC, you must have. Professor may be telling you the particular section, etc., but you must know it. Because every time you read this section again and again, you get a different interpretation and better interpretation. If you see section 17, if it is not before you, I will tell you that you can note down and you can read it later on. There are subsections 17, 1, A, B, C, D and E. Now when we talk about section 17, it says that following documents shall be registered. Reading section 17, that following documents shall be compulsory registered. The beauty of this is, therefore I will explain to you first. Beauty is, if you see only A and D, it contemplates only a specific document. If you see B, C and E, it doesn't lay down any specific document. Another beauty is, it says, following documents are registered in that case, compulsory required to be registered. Now what is A? I will give just example and then I will go on to explain to you something. Most important aspect in the book, A talks about gifts, whereas D talks about lease year to year or exceeding 1 year. B, C and E does not contemplate, but it gives a separate different aspect. I will explain you. Friends, another beauty is to be seen and that you must understand is that section 17 contemplates following documents. But if you see, read A, B, C, D and E, it uses the word instrument. When I first, after my LLB, when I started reading it, about that time, Registration Act was not the subject for in a purpose. I asked me question, A, B, C, D, nowhere uses the word document. It uses the word instrument. If you have got a book, you can very well see it. It says the instrument of a gift. D says the instrument of a lease. C, B, C, D contemplates instrument, that is non-testamentary, here word used, non-testamentary documents. Another beauty aspect is questions to my mind. The word document or instrument has not been defined in entire Registration Act. Then what is the difference between document and registration? Why legislature uses the word document and why legislature uses the word instrument? Because we are known, we understand interpretation, legislature never uses the word without any meaning. Why document is used, an instrument? Whether there is a difference between document and instrument? Yes, there is a difference between document and instrument. Now then, where do we find the definition of instrument? A Stamp Act which is related to the Registration Act. If you see section 3 into bracket 4, which contemplates what is meant by instrument. What is that instrument? It says instrument which creates some right, interest, limits, extinguish, etc. That means it changes the legal relationship. It changes the legal relationship. What does it mean? I will explain to you while considering this. So, instrument contemplates certain transfer of a particular property, some particular change in the legal relationship which may create right, transfer right, assign the right, declare certain right, extinguish right. All these wordings are there. That is the case of an instrument. That definition we find, and law is that if a particular definition is not given in a particular act, either you have to consider a related act or even a dictionary meaning. In so many cases, Supreme Court uses the word Blacklock's dictionary. You must have heard it. You must have seen it. That definition can be considered. So my friend, therefore, instrument which I told you, which creates certain rights, which creates certain extinguish or limits certain right, assign certain rights, that is the meaning of instrument. Then what is meant by document? The nearer definition we find in Indian Evidence Act, particularly section 3. Section 3 contemplates what is meant by a document. Now my friends, when we see what is the definition of a document, and the new section that is section 2(1)(d), the Bharatiya Sakya Vidhan. Earlier it was a section 3. It contemplates a document means otherwise express, each word of it, express, describe or otherwise recorded upon any substance. See each word that legislature uses the word. Or any other means intended to use or to be used as a matter of record. Exactly applicable in our case. Therefore, when we say instrument means create a right, assigns a right, transfers a right. For example, in the case I have read, or extinguishes the right, when say legal relationship, get a sale as contemplated by section 54 of the Transfer of Property. What section 54 contemplates? Section 54 contemplates a document wherein ownership is transferred. But I will tell you, my friend, for example, I say, or a lease. Lease is executed. Now, section 105 of the Transfer of Property Act. What is transferred in the lease? In section 54 Transfer of Property Act contemplates ownership is transferred. Ownership is what? A bundle of rights. If you have studied in the jurisprudence what Salmon said, ownership is a bundle of right. What is meant by this bundle of right? A lease. Ownership is a complete transfer. Whether lease is a complete transfer? No. If you see section 105, it says possession and enjoyment. One of the fiber of the ownership. If I am an owner, what right I get as an owner? I can dispose of the property, I can sell the property, I can even throw the property. Suppose a diamond which is owned by a particular lady, she goes and throws it on the road. Somebody asks her, "Oh, what you are doing?" But she said, "It is none of your business, it is my diamond. I will throw it, I will keep it, I will give it." Just like in Hindu law, we say self-acquired property. No son can question why you are giving it. He says that, "Well, I will create a trust, I will give to the trust. I will give a beggar standing on the tree, you can't ask me." Co-personal property, can you do that? No. Ownership is a bundle of right. Right to dispose of, right to use, right to enjoy, right to possess, right to create in government. So what I created that by lease, possession and enjoyment. If you see the definition of section 105 property, it says that lease means transfer of possession and enjoyment for a particular period, and consideration is either rent or any other consideration, but that means that one case. Ownership. Example was given by me during speech. Ownership, transfer of property by monetary consideration. If I say that I will give you this flat, you give me that plot, it's not a sale, it is an exchange. Bundle of right. He transfers his ownership, I transfer my ownership. If there is a difference, I compensate by money. It is an exchange, not a sale. Now, what is transferred in the lease is only one of the interest. That is what we call one of the fiber, which is one of my right. Then what is distinguished in case of a sale? A sells the property to B, B becomes an absolute owner. It's an instrument compulsory required to be leased. Lease. What is transferred? Possession and enjoyment. Now in sale, B gets the complete ownership. What is the extinguishment? A loses his title. A is no more a owner. That is an extinguishment, but not limiting it. See, therefore, it's a combination of several sections. You must understand what is the doctrine of ownership, what is the doctrine of particular bundle of rights. What is mortgage? What is a mortgage? There are 5 types of mortgage. Mortgage is creating any interest for a security of a purpose of repayment of the loan. Section 58 of the Transfer of Property Act. So therefore, in a sense, a right to sell the property. What the particular creditor gets a right is a sort of a security created by mortgage, compulsory required to be registered when we see it. But then what is that proof? He says that, well, yes, mortgage is a property given. If person who mortgages the property owner, he is the owner of the property. In simple mortgage, ownership is never transferred. There are 5 types of mortgage. We shall not take time on that. But in mortgage, what is transferred is an interest, one of the fiber. What is that interest? If the mortgagee is having that particular document, mortgage or committed default for security of a loan. Bank gives a loan. When you see a securitization act, how connections are there with each and every act? Bank says, with securitization, they have given me the property by mortgage. He doesn't pay within a period of 3 years, which was the time along with the interest and the cost. I have right to sell. Mortgagee sells the property. Is he owner? No. What is his right? Only for the security, for repayment of the loan. So therefore he said, suppose the property is up to 3 crores, loan is 1 crore. He can sell it, get 1 crore, 2 crore will have to return the money. See, what is transfer is only interest, that is the right to sell. Mortgage has no right because he is not the owner. His title is only for the security. See, from that angle you have to see. Therefore, mortgage is an instrument. Lease is an instrument. Sale deed is an instrument. Let us come back to that part of what is meant by a document. Promissory note is a document. Partition, see, promissory note is a document. Plan, suppose immovable property is sold. It says figures, map, etc. in that location. So therefore map is said, who say delineated by these, or easement right is created, delineated by this particular red line. That map is what? Is a document. Whether required to be registered? No. Maybe along with the document. But individually not required to be registered. It doesn't create any right to transfer the property. It's a document. आपण रस्त्याने येताना मी पहिल्यांदा जेव्हा आलो मी एका ठिकाणी वाचलं वकील झाल्यानंतर मैलाचा दगड आहे स्टोन माइलस्टोन इज इट अ डॉक्युमेंट येस इट इज अ डॉक्युमेंट व्हॉट इट शोज इट इज recorded display recorded description given that well Nashik 225 miles is a document whether it is required to be registered no question of registration. And therefore there is a provision in the Indian Evidence Act. If you read the original Act, section 64, 65, where the secondary evidence can be given. If I say that, well, suppose in a criminal matter question arises and he says, say, where accident took place, at a particular place, how much Nashik was there, we will put it, what around say 50, what is the evidence? He produces that photograph of that permanent. Can court say, is it a registered document? Is it a document written something? Something is written on that stone. Is a document. But I will give food for thought. Whether a love letter is a document. A writes a letter to B expressing तेरे सिवा कुछ नहीं मेरी जिंदगी में तू ही है. Love letter is written. Is it a document? Yes, it is a document. Whether it got to be registered? Answer is no. Doesn't create any right, doesn't transfer anything. It's only expression. But take example in a case when we consider in the criminal matters sometimes that well, picture मध्ये आपण म्हणतो ना की force law improved. What was his intention? He was doing it, he was doing this. It's a letter. Or go one time that if you have seen the history in Mahabharata, I put it, I am not boasting myself, but always my wife never takes me to the picture. What they show is humbug, Indian Evidence Act. कुठेतरी कोणीतरी तो मारून म्हणतो मुझे कुछ कहना है. Whether such a permissible evidence, not permissible. I say this is contrary to the Evidence Act. बायको म्हणते तुमचा Evidence Act पुस्तकात ठेवा. आता एक आपण मूवी बघायला आपण मूवी बघू आपण. My friends, take example, you must have read it in the book. मला एकदा असा प्रश्न पडला. ज्या वेळेला पांडवांना हाकलून दिलं आणि त्यांनी शेवटी पाचशे म्हणजे आले आंबा खातो कुठं तुम्हाला हे वाचायला नाही मिळणार आमच्या डोक्यात ना आलेले. आणि ज्या वेळेला त्यांनी काही तुमचं हे केलं आणि सगळं बोलवलं आणि त्यांनी कौरवांना बोलवलं स्वतःच्या खांडव मनात सगळं हे केलं बोलवलं. दुर्योधनाला आणि त्याला फसवण्यासाठी कारण त्याच्यामध्ये होण्यासाठी द्रौपदीने काय केलं तुम्ही वाचलं असेल. आपण ती सिरियल पण बघितली त्याच्या पाण्यावरती रांगोळी काय म्हणजे त्याचं रांगोळीचं डॉक्युमेंट म्हणजे त्या रांगोळीचं डॉक्युमेंट. No, why? Which is not substance. पाणी हरवले की गेली रांगोळी. It is not on substance. Therefore it cannot be documented. It has to be recorded. It must be, can be used or can be used. That is the definition section 3 in the Evidence Act contemplates. So therefore my friends, we have to consider from these small parameters. Always जोपर्यंत वकिलाला असा प्रश्न पडत नाही असं का आणि का हे कसं आणि हाऊ अँड व्हाय. द advocates would always ask how and why is bound to be decided in this practice. Always why, when, how. Then he goes for we are asking that and he has to search, he has to find it out. Therefore I say try to find out. See my friends, Vyangachitra, caricature. It is a document. Give answer as that you have been told that well, when you write substance, write in there whether that is a document. I will not give answer this at this time. My friends, these are the aspects why I am required to see. You must understand each and every word and interpret. Why I told you today this? When I read, following documents are compulsory required to be registered. And in the entire body, what is written? Instrument. So therefore, you must have been taught in the first or second LLB. Every contract is an agreement. But every agreement is not a contract. Reason is, contract is enforceable. That agreement will become a contract when it stands to the all the tests which was told by us. Therefore, in the case, proposal, acceptance, consideration, and consideration, valid consideration. If it is hit by public policy, section 53, that was the example. If the property is looted by the robbers, partnership is formed under the Indian Partnership Act. It is a valid partnership. No. These are the questions we must always ask. What thinking? आपल्याला लोक वेडे म्हणजे तरी चालते. मी तर म्हणतो द्याट वाको अडोकेट इज अन अडोकेट हु इज कॉल्ड वेडा. कायम डोक्यामध्ये सारखे वेद पाहिजे. सी वर्तमानमध्ये आपण कुठेही शांत बसलेला असलो आणि आपण विचारला अरे आज हा डॉक्युमेंट निघाला, आज हे डॉक्युमेंट निघाला, ते निघालं. What is the importance of it? Always thinking over it. And then make a search. You will find it. So I was on the point. Sorry, little because this subject, if you tell me teach it for this only one, this is not registration of document. 15 days, 1 month, will consist. I have to complete it within a short span because I have to see. Otherwise, प्रश्न असा होतो, मुलं कंटाळली की असं म्हणतील, याला कुणी आणलाय? पुढच्या वेळेला नका. My friends, see the beauty of this particular subject. I like this subject very much. So therefore, my friends, therefore we can make a definition. Every instrument is a document, but every document is not an instrument. Am I correct? Tell me, this definition will not find. The definition which I have made, it is correct or not? Tell me. If you say wrong, I will going to accept it. Yes, Panchak. Am I right or wrong? Don't say because I am sure, therefore don't say that it is right. I think it will be right. Every instrument is a document, but every document is not an instrument. Today, try to learn a different definition in that. Then we have to go, my friends. After this program, we have to understand one more thing. I told you, A and D says, A specifically says, a gift. D says, leases, year to year, exceeding 1 year. Whereas B, C and E, let us see what B, C, E says. B uses the word, my friends, I have noted down this. I wanted to tell you that will explain the distinction between these. Why this phraseology has come. Now my friends, the B says, in that case, non-testamentary document. Creating right, leave, right, transfer, extinguish, like same thing. B uses, C uses, non-testamentary, again some difference. He says non-testamentary instrument, that is C, B also says non-testamentary instrument, transferring, assigning right, title, any decree or order. E is different from B and C. That means a right is created by a particular decree. Normal question will arise in my mind, whether decree passed by the court, every decree passed by the court is required to be registered? No. That cannot be the intention. Otherwise they have said, well, every decree is doing that way. So we have to understand that clause number E. We have to understand certain distinctions in law. Non-testamentary, again no definition. Then what is meant by my friends? What we have understood, though we have understood, any time read it, what is meant by non-testamentary instrument? Non-testamentary instrument. I am just asking, have a dialogue. I am not just like, because don't have the impression that I am taking a lecture in the classroom and asking the question. It's just a dialogue. Word testament, what is mean by testament? Dictionary meaning, not in registration act. Testament means one's will. Therefore, testamentary, it is an adjective relating to the will. Wording is non-testamentary. That means such document other than will, which creates right, extinguishes right, limits right, is compulsory required to be registered. Therefore, clause A says gift. Then what is the difference between gift and will? Ultimate effect is the same. Gifted by, as defined in section 122 of the Transfer of Property Act, a gift of any movable or immovable property by one person called donor in favor of another person called donee without consideration. That is most important. Maybe between relation from father to daughter, from mother to particular son. This, without any consideration. But clause A says it is required to be registered compulsorily. What is will? Will, the will called as testator. What he gives is called bequeath. The testator bequeaths any movable or immovable property. If you see the definition of the Indian Succession Act, section 2, what it contemplates? It bequeaths certain property. My will is not compulsory required. Will is also without any consideration. It is my choice. I like, I give it. Therefore, I give the example. It is my self-acquired property. You must know the law if you are taking the cross-examination. You must know the law. What is will? What is gift? I will take you stages how the document proceeds, and accordingly I will take the lecture. That I want to note it down point, one by one, step by step. Will takes effect when? Will takes effect when? After the death of the testator. So no immediate passing time. By will also title is passed. By gift also title is passed without any consideration. Gift immediate effect. Will after the date. See the difference. Will is not registered compulsory required. It's optional. If you read these particular sections, this 17(2), that particular clause which is specifically stated. So my friends, these aspects need to be taken into account. Therefore, we have to understand what is the concept of a non-testamentary document. And in case of non-testamentary documents, you can very well say that, well, therefore will is not. In Transfer of Property Act or Conveyancing word, what different is used for all these documents? Transfer inter vivas. What is the meaning of it? Transfer inter vivas, that is during the lifetime of those particular persons. By one living person to another living person is beyond inter vivas. Will is a transfer, but which by a person who dies and beneficiary, that is legatee, who is alive. This is what happens. So therefore these aspects need to be taken into consideration. Instrument, I was pointing out certain aspect. I see that well whether something is left out later on, that preliminary aspect. Now my friends, I therefore told you, traveler, I thought it fit. These niceties of those words you must understand in their full case. Now my friend, let us consider in their full case now clause number 8. That is all gifts. Now, my friends, you have to understand every time Registration Act, we have to read along with the transfer of property. Second 122, I told you that one person gives the property, transfer the property, movable or even immovable, without any consideration. Person who gives the property is the donor, to whom he gives the loan. Section 123, a rider puts a restriction on 120. What it says? Every, that is section 123 says, every instrument of a gift must be writing, registered, and by 2 attesting witnesses. My friends, when we take cross-examination, I was recently taking the cross. Judge was surprised, the other side was surprised, very MD of a company. I put that profession to make a search on that. Gift is executed, not presented for registration. Within paying when you consider a period of 4 months. And after she dies, that mother had given allay, because of our cases it's a fabricated document. Mother dies, not presented for registration before the sub-registrar. And then, not the particular beneficiary donee, but he gives the power of attorney. These are the practical aspects. To present the document, and his particular agent present the document for registration of a gift without paying penalty after 4 to 8 months. What is the effect of it? Unless you know the law, how can you? That gift duty is right. My suit is for partition. I say that property in fact was not belonging to the mother, and assuming it was that well, gift is invalid, therefore it again comes back, and therefore I am entitled for partition. We have to know the law. This is how it helps you for cross-examination. When I told you, my friends, in a cross-examination you must be master of facts. Each and every document, each and every fact, and what is the law on this. तुम्हारा अपार प्रश्न only time we have to make study on it. So gift 123 contemplates any movable or immovable property by a registered instrument in that case, registered attesting by 2 witnesses. Question arose, therefore I am telling you, attested by 2 witnesses. There are only certain documents which require attestation. One, under the Transfer of Property Act, gift, mortgage. Section 58 says, Transfer of Property Act, every mortgage is required to be attested by 2 witnesses. I am not questioning, my friend, several lawyers, even more to what grants, they know what had happened. In one case, mortgage was produced. I was challenging the mortgage. Question arose and he started, yes, mortgage executed, etc. But go to the last page. When what? Judge said, what? When it is attested, no, it will not even attested by a single witness. But it is attested. Attestation has been defined in section 3 of the Transfer of Property. Just say, Mr. Kanetkar, attestation requires only for will. I'm sorry to say, sir, only it's a wrong. What? But open section 50. He writes twice. Yes, Mr. Kanetkar, you are right. It's not I am boasting. You must know the law. I could get that mortgage void because it was not attested by 2 witnesses. If you see section 68 of the Indian Evidence Act, read which says, unless one of the attested witnesses
examined in the open court. That is the importance. So therefore, in the mortgage is required to be attested, gift is required to be attested. There are the two documents which require. There is one bond under the particular certain provisions, and the fourth document is the will under the Indian Succession Act. And the section contemplated is section 68, how to prove a document which requires an attestation of a document. This is the combination of law. You can't read only this section, this section. To what section it is related, you will become a master of it by this. This is the meaning of it. So gift contemplates in that way. Now, I will give you one question. If you read section 123 again, I will pose one question. Immovable property, value is 100, less than 100. Which within the word in section 54, any sale, transfer of ownership, in that case transfer, in case of immovable property, where the value is 100 and above. 123, I had argued one matter this. Under section 123, it doesn't use the word value less than 100. When I argued, just said, Mr. Kanetkar, you are aware, senior lawyer, value is less, very less 100. Gifted how 100? Yes. Open 123. 123 doesn't say the value is less than 100. It's only said in section 54, not in 120.
Yes, sir. Yes.
My friends, this is the letters of law you must study. You must first study. Never say what has been taught in the colleges is not of no use. Never say. Never say. That is the basic foundation, my friends. Coming back to the point. If the value of a particular, in case of gift, movable, it has to be a question arose. Shares of the company were transferred. Some particular resolution was there and etc. Matter is still going. Big fight but two corporate brothers. I asked the question in that case when matter is going on. Whether the shares, that registration is done and with the company etc. They will say where? Movable property. Go to 123. Immovable. But I will give one more example. You are studying, you are going to study in this way. Just now, Sauri Sahib stated just now, Muslim law. You must have heard the word hiba. Whether hiba is compulsory required to be registered. Question doesn't arise, hiba is the oral gift. Where the question, what is to be registered? But hiba is iwas. There is another document in Muslims. Have you got it? Hiba is awaz. I was conducting one case, therefore I could come understand that word. In that case, what had happened was, the property was given for repayment of a debt. That contention had come. Question arose, we said that no, title has not been passed. Because question is, in that case, it is not registered. The other side laughed, hiba is not requirement, it is not hiba. It is hiba is iwas. Find out the word where property was given for repayment of a debt. I pointed out one judgment also. Make a search. When court held, it is a sale. But sale is compulsory required to be registered. Comes under the clause number B or C. Now whether you are Mohammedan or that is not the question. But hiba, compulsory. But take another example. We can learn the law by hiba. If you have conducted the cases or you come across. You know what was in Hindu, Stridhar. What is Stridhar? At the time of marriage, you must have heard it. At the time of marriage, father gives something to the daughter. Don't take it otherwise. 2-3 महिन्यापूर्वी माझ्या एका ज्युनियरचा साखरपुडा झाला आणि त्याच्यामध्ये त्याला कार दिली. माझ्याकडे तो तुझ्या नावालाच येतो, कारण त्याला गरज नाही वकिलीची, त्याला खूप मोठा आहे, पण त्याच्यामुळे त्याला ती कार मिळाली. मला आहेत का? मी आपलं सहज विचारलं, काय काय डॉक्युमेंट केला का? काहीतरी आय डी का कोणीतरी दिली, याच्यामध्ये काहीतरी दिली. काय करायचं डॉक्युमेंट? बरं ते जाऊ दे म्हणजे. बायकोला मुलीला वडिलांनी असंच काहीतरी दिलं. मी म्हटलं तिथे रजिस्टर केलं का? नाही म्हटलं अरे करायला पाहिजे, काही मिळणार नाही. उद्या जर वाद नाही तोपर्यंत ठीक आहे. म्हटलं काय कारण आहे? म्हटलं स्त्रीधन आहे, प्रॉपर्टी मोर दॅन 100 आहे. आता ओनली क्वेश्चन दॅट मे अराइज, देर आर ट्राय टू मेक अ सर्च. Suppose car is given, it's a movable property. But take example, some other along with that, स्त्रीधन is created and daughter claims a right की मला हे लग्नाच्या वेळेला माझ्या वडिलांनी दिलं. They will put it, read it, make a search over it. She is trying to claim the right. Question, no, the brother will no, you are not entitled because what is that movable property has been given to you as a stridhan, dictating the priest, that is Bhadji, etc., chanting, given this, given this, given this. That doesn't create title. Stridhan, when it is a movable property more than 100, it will be treated as a sale or a gift. It will be treated as a gift. You call it by any name, Stridhan. Ultimately, effect is what? I treat myself fortunate as such that I am required to consider such type of so many cases of their case. And I was required to read it. Rome was not built in one day, my friends. You see that well, what I am telling? No. I was required to spend and etc. This. It's not something miracle, my friends. You can do it. You can do it. Never think that, well, this is what only. Whenever an issue comes, read it, search it. That was the way what came with. You are a senior member of the bar, Jayavantara. Combination with law and practice. You have to find out, you have to make a search. So my friends, if a stridhan is given of this particular pattern, then I think that it is compulsory required to be registered. Then my friends, another question arises. I will take you that one now. Clause D. That is the lease deed. These are the two specific documents. Then we will consider B, C and E. And then we have to consider other certain aspects. I take your liberty, my friends, continuing that case. Am I right? I think you have no choice, you have to hear it. B says, non-testamentary documents, creating right, title, interest, etc. Limited extreme. I have already given you example of it, sale deed. I will not explain it. I have already given you particular this clause number D, so I will not repeat that. Lease every year or exceeding 1 year, when possession and enjoyment as per section 105 is transferred, it has to be registered. Because D uses only for leases, B uses, and then we will see as well. And lastly, particular E. So therefore, what B and C, they were non-testamentary documents. So therefore, we have to see what is these particular, which can be documents, which can be non-testamentary documents. And I would like to emphasize that well, you understand, create, right, transfer, etc. But one uses the word extinguishes. Right is not created, only extinguishes. I will give a specific example. Or declare. What is mean by declare? Here word declare is written partition. Property joined into family or co-personal property, they enter into a particular document, partition deed. Whether partition is a transfer. Word is create, transfer. No doubt there is only one judgment I remember, find out a case. In 1998, Supreme Court has stated, this is a grey area. Law settled is partition is not a transfer. What is partition, my friends? It only declares specific shares of each member of the family. That is mean by it. Comes under the clause number B. When the partition deed is executed, declaring this property goes to A, this property goes to this, according to his share, documents compulsory required to be registered. If it is not registered, suit for partition has been filed, and if you take a defense, no, partition has already taken place, you can say it is not registered, it will not create. But there is one concept, there is one phrase, in case you will find some agreement to partition. Whether agreement to partition is required to be registered. Compare with agreement to sell. Compare with agreement to lease. See, food for thought. Agreement or partition is not compulsory required to be registered. It is only intention to swear. In one case in Supreme Court, what has happened? When partition takes effect, if I remember correctly, it is judgment of Justice Chandrachud. When partition takes effect, when the parties have intention, actually, you may do actual partition later on. Intention is to sever the property, to go back out. One of the brothers residing at different place and say that no, I want partition. He writes a letter and says that all right, they say will partition. Partition has taken place, not actual. Because what partition says that well, by metes and bounds. So by metes and bounds, either by partition deed or by decree of suit for partition. What court does is that well, we say equitable partition. आपण मराठीत म्हणतो सरस निरसमानाने वाटणी करून मिळालं. What is that? That is equitable partition. Court does it. Whether that decree is required to be registered? No. Then which decree is required to be registered? When we will see clause number E, we will have to make a distinction. It is a distinction like that, my friend. Everywhere we have to consider this. Always. मी जोकिंगली आमच्या मुलांना किंवा ज्युनियर्सना म्हणतो, हे फक्त भाग पाडायला दिलेलं नाही. विचार करायला. पण तुला आहे तो विचार, फक्त तू आळशी आहेस. मध्ये मला एक नवीन कन्सेप्ट कळला, लेझी आहे. आमचा एक डॉक्टर मित्र होता आणि तो बोलता बोलताना आम्ही चाललो होतो इकडे गेलो. तुम्हाला काय ते काशी दिवसाला दिसत म्हणजे त्याचा एक लेझी आहे. मी पहिल्यांदा तो शब्द ऐकला, म्हणजे लेझी आहे म्हणजे काय. मेंदूमध्ये जे काही तुमची कण आहेत ते त्या डोळ्याकडे लक्ष देत नाही, त्याला सूचनाच देत नाहीत. आपण म्हणतो बघा आपल्याला मेंदू सगळा काम करतो, छोटा मेंदू मोठा मेंदू सगळा आपल्याला जातो, आपल्याला कळतं. ऍक्सिडेंट आला की आपण ब्रेक दाबतो कारण आपल्याला तो सांगतो अरे पुढं घोटाळा आहे थांब. त्या दोन पैकी एक लेझी असेल ना, तो मेंदू त्याला काही इन्स्ट्रक्शनच देत, मग तो आळशी करतो. आळशी बनतो, काम करेन असं होतो, काही दिवसांत तो बंद होतो. सिसीचं डेंजर. मी म्हटलं अरे मग त्याला काय उपाय काय. तो म्हणला लहानपणापासून ही पोरं टीव्ही बघतात, हे बघतात आणि मग काहीतरी पुढे होतो. काही नाही, त्या डोळ्याला काही डॉक्टर सांगेपर्यंत पट्टी बांधून ठेवायची. यू कंपेल हिम टू, चांगला जो डोळा आहे ना त्याला डोळा बांधायचा. म्हणजे यू कंपेल मेंदू की गिव्ह इन्स्ट्रक्शन टू दॅट लेझी आय, यूज युअर लेझी आय. इट इज द ओनली मेडिसिन. माय फ्रेंड, तसं मी तुम्हाला त्याच्यामध्ये आता सांगत होतो. मग हे कुठं होणार मग त्याच्यामध्ये. मग बी अँड सी आपल्याला जे बघायला पाहिजे तुम्हाला वेदर पार्टिशन, वेदर पार्टिशन इज अ ट्रान्सफर. नो, इन वन जजमेंट इफ आय रिमेंबर करेक्टली, आय डोंट रिकलेक्सिबली, पार्टिशन इज नॉट ए ट्रान्सफर. It is only declaration of specific shares of each one. Take this particular subject I. Therefore I said agreement to partition, not. Agreement to lease, no. Only intention to execute. Then what is the agreement to say? See section 17(2), Roman 5. When a document, they are not like when a document is, here word used is document. To get another document is not compulsory required. What is agreement to say? See section 54, Transfer of Property Act, subsection 2, last part. They define what is meant by particular sale, and last they say, agreement to sell does not create any right. Agreement to sell does not create any right, title, and trade. What right it gives? To get another document. That is, suppose agreement to partition, get the partition. Agreement to lease, get the leasing. Agreement to sell, get the transfer. And therefore, in a suit for specific performance, what we say? There is an agreement to sell. I am ready and willing. See everywhere how law is connected. I am ready and willing. I have paid 80%, but I am ready to pay balance amount. Compel him to grant me a specific performance and direct him to execute a sale deed. Means 1725 Roman 5. Document for getting another document. That is the agreement. This is what I like. So agreement to say why it is not compulsory corporate. But law is changing, my friends. You have to understand that. See section 4, Baburao Ownership Flat Act, which is also applicable in us. It is applicable only in certain terms. Baburao Ownership Flat, which is called as a Builder Regulatory Act, Developer Regulatory Act, because they committed all mischiefs and skewed the blood of the flat holders. In 1963, a committee was appointed by the government known as Care Committee, and they say that will pass this act. And therefore they have stated, wording is what? You must always remember that well. Notwithstanding anything contained in any other law for the time in import, if any agreement to sell by a developer, promoter, and builder in favor of purchaser, for a consideration which is to not be taken at more than 20%, is compulsory required to be registered. My friends, law was required to change. Till today that is the same. In 1983, Justice Jagidar of Bombay High Court gave a judgment. R.H. Jagidar Monote. A flat owner filed a suit for specific performance. Everything was paid. Jagidar said, I am in tears, but I am required to dispute the suit. Effect of non-registration. Document is not admissible. Agreement to sell by builder in favor of flat holder not registered. Suit dismissed. Section 4(1)(a) was introduced after the judgment and decree. Read that section 4(1)(a), which says that when notwithstanding anything contained, that is the wording of section 49C, which I am going to say non-effect of registration. Section 49 say when we say one of the effect, which is today's next topic, that is, what is the effect of non-registration? 49C says all other not admissible later, but such a particular document can be used only for the purpose of proving the contract in a suit for specific performance, that is 49C. Same wording taken and introduced in section 4(1)(a). Earlier, this argument was advanced, 49C. Justice Jagidar read the judgment, he said, no, I am aware 49C. But he stated, he held, notwithstanding anything contained in any other law for the time being in force, will not invoke 49C. See, the legislature was required to amend this section 4 and 4(1)(a) was introduced. So my friend, an agreement to sale, when we consider another aspect, so this is what, so far agreement to sale is not compulsory required to be registered, but in certain cases, this is required too. So therefore I was on the point, in case of an agreement to sale. Take one more aspect. I am giving example which you always come across. Sale certificate. Have you heard the word sale certificate? Order 21, Rule 94 CPC. If not pay, auction is there, and court issues the sale certificate. Food for thought, whether the sale certificate is compulsory required to be registered. General answer, no. But as for the Maharashtra, there is this provision incorporated that one sale certificate is also compulsory required to be registered in Maharashtra. That is the Maharashtra amendment. So when we consider, we have to consider all the relative laws. That is the important aspect, my friends. So therefore I told you, my friends, I told you in that case regarding the Hiba, there is one more aspect you should acknowledge that way. Sometimes you come across, and that helps you in convincing to guide your client. Before 10-15 days, it should not be good on my part, very giant particular in this judiciary. We came and that some disputes were there. He said that we can't execute a partition deed. We have no stake now to go in the court and partition. Kanetkar, please suggest a particular right. It was very old one, nothing. I say, oral partition is permitted according to the Hindu law. There are judgments on that. But evidence is not there. What you can do? You can execute a memorandum of partition. Memorandum of partition means recording a past transaction. There is the skill of a convincing lawyer. You have to weigh that well. That between among and what? Supreme Court, there are judgment. If I remember correctly, Kade versus Kade, 1976, Supreme Court says we give highest importance to the family arrangements and settlements. I knew that, therefore I immediately gave the advice. And wherein they just said in that case, in order to maintain wordings, I use the same word. And that judge said that, what you are drafted, but I have not drafted, Supreme Court has taken. In order to maintain the reputation and in order to avoid the dispute in future, we have arrived at arrangement. Same wording, I put it in that memorandum of party. And I say only put a date. So he said my another son is going to Singapore. So when he has come before one, I say oral partition took place between so and so, so and so. But in order to avoid any further dispute, we are recording what is agreed orally in order to maintain the reputation of the family and avoid any dispute in future. There will be a registration? No registration. Settle down. Judgment of Supreme Court. When I tell always you must know only not section, how it is interpreted by any high court or a particular Supreme. You can give advice. आता तुम्ही म्हणाल काय advice दिला, कसला advice? हे मी वाचलेलं होतं, मला माहिती होतं, पण दिला advice. My friends, these are the aspects to be taken. So memorandum of oral partition is not required to be released. Even in Hindu, don't forget about Hiba in there. They are concerned entitled for personal law. We are also entitled for personal law. Only thing is that well, you have to read 2005 amendment in Hindu law. Any partition registered before 28th of December 2004. There I argued one thing. Jayant Raghavati was witness for that. At Akluz, we had a conference and I stated there are plethora of judgments where Supreme Court says there are oral party.